This is cause number 327-840, case of style, State of Texas versus Tracy Marie Samuel. Ms. Samuel, you can, Ms. Samuel is appearing via Zoom. Ms. Samuel, you could take your mic off of mute.
Yes, sir.
Ms. Samuel, how are you doing?
I'm okay.
Okay, now, Ms. Samuel, you're here, well, you're appearing via Zoom, and your attorney, Mr. Bruce Cobb, is present in the court. Mr. Cobb, how are you doing?
I'm doing fine, Your Honor.
Mr. Cobb, you have an announcement you'd like to make in Ms. Samuel's case?
Yes, we're going to do a plea, Your Honor. She's agreed to go ahead and do a plea. The only thing is that today she can only be present by Zoom.
Okay,
If we could reset for any subsequent Friday.
let's look at Friday next week.
Right.
Okay, it's gonna be, your case, Ms. Samuel, is gonna be reset till July 23rd, which is next Friday. You have to appear in person. Ms. Samuel, your attorney will be, your attorney, your bondsman will, well, PR bond. Your attorney will be given a copy of the reset. You just need to stay in contact with your attorney. You need to be in court at 9 o'clock on July 23rd, 2021, which is next Friday.
Yes, sir.
Okay, this will conclude your case. You have a blessed day.
Thank you.
All right, and Mr. Cobb, okay,
Yes, sir.
you could get your reset, stand over there and get your reset.
Yes, sir.
Bye.
Bye, you're free to go.
Okay.
Okay. Oh, wait, there you go. Mr. Boudreaux? Y'all come back. Okay. So we're back on the record and,
I'm not ready.
no, oh, we will not on the record on this.
Oh,
Okay. We, we're back with cause number 328760. The case is styled, the State of Texas versus Ashley Christian Pressler.
yes.
And previously, Ms. Pressler pled no contest to the offense of possession of a controlled substance, penalty group 2. The state had alleged different theories of committing the same offense, 2 different theories of committing the same offense, and the state in this information has 2 paragraphs. And the state is not required to elect among different methods of committing one offense, okay? And so, Ms. Pressler, as I said previously, you, and this just statement that I just made, the state is not required to elect among different methods of committing one offense. That's pursuant to Kitchens versus State, 823 Southwest 2nd, 556, excuse me, 256. Now, Ms. Pressler, you previously played no contest. You also previously acknowledged that your initials and signatures on State's Exhibit number 1, and you also acknowledged that your signature was on the trial court certification, the defendant's right of appeal, and you also acknowledged that you understood the two boxes that was checked on the trial court certification, the defendant's right of appeal. You also acknowledged your signature on the discovery certification. The state announced that you were being offered 90 days confinement in Jefferson County Jail. However, that would be probated for 1 year, and your fine would be $750 plus court costs, 80 hours of community service, and you would have to attend a drug education class. Now, the 1 year, the confinement of 90 days in the Jefferson County Jail, you would not have to serve any time in the Jefferson County Jail. However, that time will be probated for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $750 plus court costs. The court costs and fine comes to a total of $1,157. You'll also be required to pay a fee to reimburse the crime lab, a fee of $100 to reimburse the crime lab. You will be required to pay a probation fee of $60 each month and a urinalysis fee of $15 each month. And you'll also be required to reimburse a court-appointed attorney's fees of $250. Do I have a copy of, can I get a copy of what affidavit indigency? The total monthly installments in this case will be in the amount of $205 per month. Ms. Presley, would you be able to pay the $205 per month?
Yes.
You will? You will also be required to perform 80 hours of community service. I guess, attend a drug education class. You will also be required to adhere to the other terms and conditions of this probation. Ms. Presley, do you understand the state's offer?
Yes.
And do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Ms. Pressler, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Pressler, please stand on the X next to your attorney. And once, and follow the directions of the court clerk. Once you finish following the directions of the court clerk, you'll be free to go and you have a blessed day, Ms. Pressler. And this will conclude your case, Mr. Boudreaux. Once you finish signing the paperwork, you'll be free to go as well, and you have a blessed day.
Thank you, Jerry.
Okay. Oh, I should have, yeah. I think that's right, yeah. Okay, now. This is cause number 3283886. In case is Style of State of Texas versus John Scott Washington Jr. Is that your full name?
Yes, sir.
Now, Mr. Washington, I have the results of your drug test. It was negative. So that indicates to the court that you didn't violate your bond conditions. So you need to continue to adhere to your bond conditions.
Yes, sir.
Now, thank you. There, in your bond condition, you were required to submit to a substance abuse assessment at the Jefferson County Community Supervision and Corrections Department. And Ms. Barlow, would you please state to the court the recommendations of that assessment?
The assessment recommended that he attend an AA or NA classes 3 times a week and participate with a doctor regarding his anxiety issues.
Okay, and so, Mr. Did we get? Is this? Did we get? Oh, it's 2 pages. I can't. Okay, this looks like it was hard for me to tell a copy from the original. You could get that to Mr. Washington if you don't mind. Mr. Washington, I'm giving you some first amended standard bond conditions.
Yes, sir.
And first, I'll go over these conditions with you.
Yes, sir.
And it reads, following arrest and or accusation in County Court Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or others subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure 17.44, Section A2 and Section C2. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any resident, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply because it only applies in the DWI case, and you do not have a DWI case. So we will go to, have condition number 5. Attend AA/NA meetings 3 times a week and provide proof to the court. Do you understand that?
Yes, sir.
And condition number 6, attend and receive mental health services at Spindletop Center. Do you understand that?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be forfeited and warrant can be issued for your arrest, and you can be placed in a county jail.
Yes, sir.
All right. Now, let's see. So that's your copy, your amended copy. And also now I see here we have a judge's explanation. You amended your choice as to what you wanted, your 3 options. Your 3 options was you may hire an attorney. The second option was if you do not have enough money to hire an attorney, you may request an attorney to be appointed to represent you. And the third option was you may represent yourself. Now, previously, when the explanations was read and given to you, you had chose to hire your own attorney. But I understand that now you have changed your choice. You've had some changes in your work,
Yes, sir.
and you are requesting to apply for court-appointed attorney. Is that correct?
Yes, sir.
Now, I have before me the affidavit of indigency that you have filled out, and let me show it to you.
Yes, sir.
You recognize this document.
Yes, sir.
And did you have an opportunity to read everything on this document? And is everything on this document true and correct to the best of your knowledge? Okay. So based on the information that you have provided to the court, you meet the eligibility requirements of a court-appointed attorney. I need to, hold on a minute. Okay, so Antoine Freeman is going to be appointed to represent you. You need to, your case is going to be reset, so, but you need to stand on the X in front of the clerk first, and once you finish here, then you're going to go to the next court coordinator and stand on the X. And she's going to give you all the information that you need to get in contact with your attorney. Okay. Yes.
Getting all on me and stuff. I got it from her. I got it.
Okay, the person that just came on Zoom, would you please identify yourself?
Yes, Zachary Johnson.
Johnson?
Yes.
Oh, okay, Jackree. Okay. Your attorney came in early. He told us you was gonna be calling in on Zoom. Just hold on. He said he had to go to the jail and he was gonna come back. So just hold on. And put your mic on mute. And then when we're ready for you, we'll call your case.
Okay. The thing about I was in the wrong courtroom. I was in John Stevens' courtroom. That's what the holdup was.
Okay. Well,
I
I didn't know that.
realized that this number that I had 3 different numbers on the
Okay. Well, just
meeting
hold
room
on.
numbers.
Okay. Your attorney said that when your attorney gets back, we'll call your case. So just put your mic on mute.
All right.
All right.
Oh, Michael.
We're on the record in two cases. First case is cause number 322633, excuse me. Let me repeat that. First case is cause number 322623, and the second case is cause number 324253. All two cases are styled the state of Texas versus Gustavo Gomez Vasquez. We have Mr. Vasquez, is that your full name?
Yes, sir.
Mr. Vasquez, would you please raise your right hand? Mr. Vasquez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
You may put your hand down. How you doing, Mr. Vasquez? Now, Mr. Vasquez, in cause number 322263, the information alleges that on or about January 18th, excuse me, on January 16th of 2019, while you were in Jefferson County, Texas, that you committed to Class B misdemeanor offensive theft. Mr. Vasquez, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Vasquez, how do you plead? Guilty, not guilty, or no contest?
No contest.
No contest. Now, you pleaded no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Vasquez, I have before me a document that is titled the misdemeanor plea admonishments. And on this document, this is also labeled as State's Exhibit Number 1. Mr. Vasquez, do you recognize this document?
Yes, sir.
On page 2 of the same document, Mr. Vasquez, there's a set of initials GV on a line that is next to a box that's checked nolo contendere. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, Mr. Vasquez, there's a signature above the line that's titled defendant. Did you sign this document?
Yes, sir.
On the next document, Mr. Vasquez, that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
Is that your signature above the line that's titled defendant?
Yes, sir.
There are two boxes that are checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving, which means you're giving up your right to appeal. Do you understand that?
Yes, sir.
Now, Mr. Vasquez, are you a U.S. citizen?
No, sir.
Okay, now, Mr. Vasquez, what country are you from?
Mexico.
Mexico? Mr. Vasquez, in State's Exhibit Number 1, a paragraph that's titled citizenship. I will read this to you. If you are not a U.S. citizen, a plea of guilty or nolo contendere may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Vasquez, do you understand that paragraph?
Yes, sir.
Okay. Mr. Kyle, would you have Mr. Vasquez to initial next to the paragraph that I've just read, the citizenship,
Yes, sir.
acknowledging that he read and understand that?
Well, and Your Honor, for the record, I wanted to make sure this reason why we have the court reporter, that under Padilla versus Kentucky, I did admonish Mr. Vasquez that there is, you could have a risk of deportation, although it's not certain. that
Right.
it will happen, but it does involve that. That's why we wanted to have the court reporter.
Okay,
Okay.
okay. Now, Mr. Vasquez, did you sign a document that is titled discovery certification?
Yes, Your Honor. This is here.
Yeah, let's put 53, okay.
Is that it?
This is a second case,
Okay. Here's the one.
okay. Okay, now, Mr. Vasquez, I have before me a document that is titled Discovery Certification. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Vasquez, prior to signing all of the documents that I've just mentioned, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me state's exhibit number 1, which is the misdemeanor plea admonishment. State, you like to offer state's exhibit number 1 and any other exhibits?
Yes, Your Honor. Also like to offer State's Exhibit 2, the probable cause affidavit.
Now, Mr. Cobb, do you have any objections to the state's offering state's exhibit number 1 and 2 in this case?
No objections, Your Honor.
Okay, no objection. State's exhibits number 1 and state's exhibit number 2 are admitted. Mr. Cobb, you have advised and counseled Mr. Vasquez. Is there any evidence that he is currently mentally incompetent to stand trial?
None, Your Honor.
Mr. Vasquez, your attorney, Mr. Cobb, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Vasquez, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers are freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
The agreement is for 90 days, probated over 1 year, no fine, 40 hours community service, a theft class, restitution in the amount of $168.07 to Pioneer Supply Company, and that's to run concurrent with cause number 324253.
Okay. Mr. Vasquez, the state is offering that you serve 90 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail in this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you will not be required to pay a fine. However, you will be required to pay court costs of $352. You will not be required to pay probation fee in this case because if you have another case, that other case, you'll be required to pay it in the other case. You'll be required to pay a year analysis fee of $15 each month. And yeah. Oh, okay. And you'll be required to pay the court-appointed attorney's fees in this case of $50. Now, your total monthly installments in this case each month will be $55. Mr. Vasquez, would you be able to pay the $55 each month?
Yes, sir.
You will also be required to perform 40 hours of community service. And you'll be required to pay restitution in the amount of $168.07 payable to Pioneer Supply Company. This case, you will also be required to attend a theft class as a condition of your probation. And this case will run concurrent with cause number 324253. And you will also be required to adhere to the other standard terms and conditions of your probation. Mr. Vasquez, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Okay, Mr. Vasquez, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Vasquez, I have another case, and this other case that we have is cause number 324253. And in this case, Mr. Vasquez, the information alleges that on or about May 8 of 2019, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of cruelty to animals. Do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Vasquez, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you pleaded no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Okay, Mr. Vasquez, I have before me a document that is titled misdemeanor plea admonishments. Do you recognize, it's also labeled as State's Exhibit 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on the line next, GV. It's next to a box that's checked no contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, Mr. Vasquez, there's a signature at the top above the line that's titled defendant. Did you sign this document?
Yes, sir.
On the next document, Mr. Vasquez, well, do you recognize this document? It's the trial court certification of defendant's right of appeal. You recognize it?
Yes, sir.
Is that your signature on the line that's titled defendant?
Yes, sir.
There are two boxes just checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that? The second box states that you're waiving, which means you're giving up your right to the appeal. Do you understand that?
Yes, sir.
I also have before me a document that is titled discovery certification. Do you recognize this document? Is that your signature on the line that's titled defendant?
Yes, sir.
Mr. Vasquez, prior to signing and initialing these documents that I've just mentioned, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Vasquez, in these documents, in State's Exhibit number 1, it's the same paragraph that I read to you previously, and that paragraph states that if you're not a U.S. citizen or plead guilty or no contender, may result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Do you understand that?
Yes, sir.
Okay, Mr. Vasquez, would you please initial that paragraph signifying that you that has been read and you understand that paragraph? Okay, now, Mr. Vasquez, these documents that was that you've initialed and signed, is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishments. Would you also like to offer State's Exhibit number 2, probable cause affidavit?
Yes, Your Honor.
Any objections?
No objections, but Your Honor, again, I want to say that I did counsel Mr. Vasquez with respect to Padilla versus Kentucky, with respect to the fact that he is not a citizen of this country. And any plea, he does face that risk of deportation. However, small or whatever, but I did advise him about that. So I'm gonna put that on the record.
Okay. It will be so noted. And you have any objections to State's Exhibit 1 and 2?
No objection.
No objections. Okay, State's Exhibit number 1 and 2 will be admitted. Mr. Cobb, you've advised and counsel, Mr. Vasquez, is there any evidence that he's currently mentally incompetent to stand trial in this case?
No, Your Honor.
Mr. Vasquez, your attorney, Mr. Cobb has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Mr. Vasquez, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The offer, or the agreement is for 270 days, probated over 2 years, a $2,000 fine, 100 hours community service, and that's to run concurrent with cause number 322623.
Oh, okay. hold on a minute. Okay. Okay, Mr. Vasquez, the state is offering that you serve 270 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail in this case because you'll be placed on probation for 2 years. During the 2-year probationary period, you'll be required to pay a fine of $2,000 and court costs of $352, which comes to a total of fine and court costs of $2,352. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to reimburse Jefferson County the court-appointed attorney's fees of $250. The total monthly installments that you will be required to pay in this case is $190 per month. Will you be able to pay the $190? Mr. Vasquez, you will also be required to perform 100 hours of community service. This case will run concurrent with cause number 322632, and you'll be required to adhere to the other standard terms and conditions of this probation. Mr. Vasquez, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Vasquez, I'll follow the plea bargaining agreement that you've entered into with the state. Mr. Vasquez, have a stand on the X where your attorney is standing. Follow the directions as clerk. Once you finish following the directions as clerk, you'll be free to go, and you have a blessed day.
You too, thank you.
You, Valson,
I'm sorry. Can I get your right thumbprint on that blue light, please?
And can I see both of Mr. Vasquez's jackets? He has a cash bond for pickup.
you got it. That's those two. This is Valson. This is the last one. It'll be the same on Valson too.
Mr. Vasquez, can I get your right thumbprint on that blue light? Not thumbprint, I'm sorry. Can I get your signature on that signature? Oh, Mr. Vasquez. If you take this downstairs to the county clerk's office, make sure you have a form of identification. Okay, take this with you and you'll be able to receive it. Just show them that paperwork they give you. The county clerk's office is on the first floor directly.
This is cause number 328888. The case is styled the state of Texas versus Yule Jacob Valson. Is that your full name? Mr. Valson, would you please raise your right hand? Mr. Valson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Valson, you may put your hand down. How you doing, Mr. Valson? That's good. Mr. Valson, you're here represented by your attorney, Mr. Tyler Blum. Mr. Blum, how are you doing?
I'm doing good, Judge.
That's good. Mr. Valson, the information in this case alleges that on or about December 20 to 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Valson, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Velson, how did you plead? Guilty, not guilty, no contest?
No contest.
Now, you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Velson, I have before me a document that is titled the misdemeanor plea admonishments. Mr. Velson, do you recognize this document?
Yes.
On page 2 of the same document, Mr. Velson, there's a set of initials on the line that's checked nola contendere, which means no contest. Are these your,
Yes.
did you place your initials on this document?
Yes.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is that your signature?
Yes.
And on the next page, Mr. Velson, well, the next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes.
Is that your signature above the line that's titled defendant?
Yes.
And there are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargaining case and you have no right of appeal. Do you understand that? The second box states that you are waiving, which means you're giving up your right to an appeal. Do you understand that? You have to speak up.
Yes.
And Mr. Velson, I also have before me a document that is titled the Discovery Certification. Do you recognize this document?
Yes.
Is that your signature on the line that's titled defendant? Mr. Velson, prior to signing and initialing all these documents that I've just mentioned, did your attorney go over these documents with you?
Yes.
And did you read and understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment. State, you like to offer States 1 and State's Exhibit 2, the probable cause affidavit?
Yes, Your Honor.
Any objections?
There's no objection.
No objections. State's Exhibit Number 1 and State's Exhibit Number 2 are admitted. Mr. LeBlanc, you advised and counseled Mr. Velson. Is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm working on.
Okay, Mr. Velson, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Velson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 180 days, probated over 1 year, an $800 fine, 80 hours community service, DWI education, drug and alcohol assessment, and interlock device.
Mr. Velson, the state is offering that you serve 180 days in Jefferson County Jail. However, you would not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $800 plus court costs of $422. The total fine and court costs comes to a total of $1,222. You'll be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, and pay the court-appointed attorney's fees of $250. You'll be required to pay the Jefferson County DWI education class and initial evaluation fee of $125 should a further, and on the day of the plea, and should a further evaluation be needed, you will be required to pay an additional $50. Now, the total amount of your monthly installments for this case will be $210. Mr. Velson, will you be able to pay the $210 each month?
Possibly.
Okay, let me get his affidavit of indigency. You got a calculator? Yeah, I'm gonna have to left mine. Could you pull it in? Okay, Mr. Velson, I have a copy of your affidavit of indigency that was, thank you, that was filled out and signed by you on May 4th of 2021. Mr. LeBlanc, could you show this to him?
Yes, yes.
And you could turn over the next page too. That's your signature on that document?
Yes, yes, that's document, filling it out.
Okay, okay. Is everything on that document true and correct to the best of your knowledge?
Yeah. Usually. Yeah, pretty much.
I mean, it's the same. It's nothing,
Yes,
yeah,
nothing changed.
nothing changed, okay.
I mean, for us, no income.
Yeah, I'm saying
no
income,
problem.
expenses, okay.
Yeah.
But what about, you say it's income, what about
Yeah, I said
expenses?
expenses, yeah.
Okay, so basically nothing has changed.
No.
And then I see you was receiving SNAP?
Food stamp?
Yes,
No, I wasn't receiving food stamp. I was receiving unemployment.
okay, well, on here it has 192 a month. Show that to him. What?
How much food costs? Oh, yeah. I know.
No,
I'm sorry. I
it's the
must have
box,
put
the
that-
box
Yeah, it
check
says
SNAP.
192. No, I don't receive food stamps. No.
He misunderstood the question. I
Yeah.
guess, Judge.
Yeah, but he checked the box that said I received SNAP.
I don't receive food stamps.
Have you received them in the past?
In the past, maybe 2-3 years ago. Yeah.
Okay.
No, I was on unemployment all this since the pandemic. I may put that in the wrong spot. That's how much food costs me a month.
Well, yeah, your food was 300. Expenses was 300.
Let me see, I don't know.
You can show that to
You
him.
just made a mistake,
Yeah, I
Judge.
don't-
Yeah, I'm just saying.
I don't get food stamps. Yeah. I don't know why I should put that there.
Okay, are you still receiving unemployment?
No. No,
So that's the change.
yes.
So okay.
Unemployment stopped with May,
So you was getting,
26 or
you was getting
something.
like 1,200 a month at that time.
Every 2 weeks. Yeah,
Okay, so you don't get no income.
nothing.
Okay, so all of this didn't change. So your income is 0. Okay. Oops. Okay. Let's see. That's 1,020.
That's the amount I was getting when I did get food stamp back in the day. So I maybe put it down like that.
Okay. That would be. Okay, thanks a lot. Thanks. Okay. Mr. Valson, the court is gonna find that you're indigent, you was found indigent previously, and so the court is gonna maintain your finding indigency. There's been some adjustments with your income that has actually gone down to 0. And so, based on that, pursuant to Article 42.15 Code of Criminal Procedure, your fine and court costs will be converted to community service. And your fine and court costs is going to be converted to 98 hours of community service. Your probation fee of $60 is going to be reduced, the $60 per month is going to be reduced to the minimum of $25 per month. Okay, and so Those adjustments are going to be made on the paperwork, and the probation office, they're gonna, the numbers is still gonna reflect $800 fine plus court costs of $442, totaling $1,222. But there will be a statement in the judgment that says that that has been converted to 98 hours of community service. And so the conversion is gonna be made through the probation office. Now, the probation fee of $60 will be adjusted on this judgment to reflect that the probation fee is the minimum of $25. Okay? So that's going to bring your total amount down substantially. All right. Now, Mr. Valson, let me just repeat this to you again. The state is offering that you serve 180 days in Jefferson County Jail. However, you will not have to serve any time in jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $800 plus court costs of $422, which comes to a total of $1,222. And that fine and court cost is going to be converted to 98 hours of community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. The probation fee of $60 is going to be reduced to the minimum of $25, and that's pursuant to the same statute. You'll also be required to pay $15 each month of for your analysis fee, and reimburse the county the $250 for court-appointed attorney's fees, and you will be required to pay a Jefferson County DWI education class and initial evaluation fee of $125. Should a further, on the day of the plea, should a further evaluation be needed, you'll be required to pay $50. Now, you'll also be required to perform 80 hours of community service. That's the regular 80 hours, plus the 98 hours that was converted from the fine and court costs, which comes to a total of 178 hours. You will be required to attend and complete a DWI education class and have a drug and alcohol assessment, install a DWI interlock device on any vehicle that you own or operate, as well as adhering to the other standard terms and conditions of probation. Mr. Valson, do you understand the state's offer and the adjustments that have been made by the court?
Yes,
And do you think it's fair and just?
yes,
And do you accept it?
yes.
Okay, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Valson, stand on the X next to your attorney. Once you finish in here with the court clerk, you'll be free to go and you have a blessed day. And Mr. LeBlanc, I think this will conclude your case. Once you sign the probation papers, you'll be free to go as well and you have a blessed day. Okay.
The other set for James Williams, schedule certification.
Be up here somewhere.
One, did they do discovery certification on the second one?
Yes, they did.
And then, raise your right hand. You swear that you never have been given a first adjudication or regular probation for a felony. Have you ever been convicted for a felony or misdemeanor?
No.
Okay, and you have no other pending charges? So you'll take that and this to the county clerk's office before you leave and, pick up your recess.
This is cause number 312974 and cause number 327932. Both cases are styled the state of Texas versus Brandon Jarrell Martin. Is that your full name?
Yes, sir.
How you doing, Mr. Martin?
I'm good. How about yourself?
I'm doing fine. Thanks for asking. Mr. Martin, you're here represented by your attorney, Mr. Tom Burbank. Mr. Burbank, how are you doing?
You're fine, Judge.
That's good. Mr. Let's see, Ms. Barlow, what is the state's, the state and the probation recommendation in this case?
Probation office is recommending revocation.
Okay, Mr. Burbank, what is your announcement?
Your Honor, there's a pending terroristic threat also.
That's
and
this one.
There is a non-prosecution affidavit floating around somewhere that I don't believe the state possibly has. Of course, we don't want him to go to jail because he has a job and doing things, but
So what's your announcement? You
well, my
announcing-
announcement at this point is if you give us a short recess so that at least the other misdemeanor can probably be dismissed. They don't have a witness.
Well, state, what's your position? I mean, you want to set it for trial? You want to set it for, what's the
other
announcement?
Case, I guess to reset, give us time to talk with the victim in that case to see, I'll call her today, see if we can get that issue resolved.
Okay, and how much time do y'all need?
Not much, Judge. Couple of weeks would be fine.
What about
30
2 weeks?
days, 30 days.
30 days?
Judge, yeah.
Okay.
And then at this point, Judge, I anticipate that we'd probably just go to the court of what we need to do.
Well,
And we'll
what,
get on
so you're talking, you talking about having a hearing on the motion to revoke probation? That's what
Right,
you're saying?
just, and what the punishment should be.
So you're saying that he's gonna, so you're talking about a plea?
Well, probably an unagreed plea to the judge
Okay, well, I
to
mean,
to let you decide.
okay, well, I mean,
There is a tentative offer of 30 days on the MTRP.
let's see. What's the guy's name, Martin? Okay, so he's looking at a possible, the range of punishment go up to 90 days. Okay,
Right.
so you can go up to, okay. So you're informed that he can get up to 90 days on the case? Okay, well,
Absolutely, Judge. I
no
mean,
guarantees what's
and
gonna happen.
most of it, once we get this underlying offense out of the way, I think it's financial.
Well, we'll see. So he's setting it for a plea?
Well, if they will, if we give sufficient proof and.
Well, are you saying setting for 30 days, so you just want to keep it on announcement docket
Sure, but at that point, Judge.
on the MTRP?
If the other offense is taken care of, then, and we can't go and
Okay.
come to an agreement on the MTRP.
Okay, so we're just gonna, okay, we're
Just
just,
let the judge, let the court decide.
well, you're gonna have, you got two cases. You have at that point, you'll have a terroristic threat case, and then you'll have a DWI case.
That's the one that should be gone.
Well, that's what you're hoping. There's no guarantees.
That's a
Okay.
guarantee.
Well.
You know that,
Hold on, let me,
I'm sorry.
you got some bond conditions?
Not on the first one, let me check the other one.
Okay, give me a. Okay. Yeah. Okay. Just make a copy of this for me, if you don't mind. I might have to give him some other ones on this one too. Okay. All right. Let me do this. I've read the, take judicial notice of the probable cause affidavit that is in the cause number 327932, which is the terroristic threat case Mr. Brandon Morton will be required, is gonna be given some bond conditions. And here. Could you copy this, get that just the last page? I changed the last page. Pull up his, internal history on what we got on. Yeah, cause number cause number 327-932. Get us going. That was it? Okay. Reach that to him. Okay, Mr. Martin, those are bond conditions. These are standard bond conditions in County Court Law number 2. I'll read these conditions to you. It says, following arrest and accusation in County Court Law number 2, Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And number 4 does not apply. And number 5, defendant, you shall participate in the GPS monitoring system by immediately obtaining the GPS monitor. Okay?
Your Honor, I'm court appointed.
Okay.
He has no money for a GPS. But number 2, the complainant is the mother of his child and have children that he supports.
Okay.
So now you've put a burden on them at this period of time when maybe it should have been done at the beginning of this offense. And so I'd ask for consideration because now you're going to destroy a family unit.
Well, I'm trying
because of
to,
money.
okay, the court is more concerned about safety of the victim in this case. I read the PC affidavit. I mean, I don't want to go into what he said he was going to do with her in this case.
Absolutely.
Yeah.
I agree with that, but
Yeah.
at this point, I mean, let's get the district attorney to try to get her in. I don't know if she's going to come in.
Okay. But in the meantime, he's going to have to adhere to these bond conditions. Okay. And I'm going to tell you this here. Your attorney probably could tell you that, as well. There is an offense that's called tampering with government witness. Okay. So at this point, if you don't adhere to these bond conditions, the warrant could be issued for your arrest, and you could be placed in the county jail.
I'm trying to do just, I'm gonna have a job.
I understand.
I'm not a bad
Okay.
person.
Just adhere to your bond conditions. Okay.
Yes, sir.
All right. Now, and at the same time, I mean, there are ways that people could communicate, not communicate, but have access to their children. I mean, if you do family law, There can be a third person who can be arranged to exchange children. So there are things that can be done without necessarily having direct contact or contact with the victim in this case. Okay?
In reference to the GPS, and I don't agree respectfully to the court in reference to no contact. I mean, they're not living together, but he has substantial contacts with the children
That's fine.
and the child. But I understand GPS is like $400-something a month,
It's around that $300-400 a month.
and I'm court appointed. Do you want it to go to child support or GPS? For support.
Well, right now, I'm saying at this point,
I'm on child support too.
okay, okay.
So, I mean, it's only so much money, I mean, to the court, I mean.
Yeah, but I mean,
Whatever I need to do to not go to jail, I'm fine with it.
okay, okay. So I mean, your client saying he's fine with it.
Wow.
I'm ready for the DWI. I've been dealing with the DWI.
Okay, well, you can talk to the attorney about, facts case. But I mean, we trying to, okay, look at it like this here. You're trying to balance the safety of the victim, right? I mean, that's one of the issues. Now, at least that's the main issue when we're concerning bond. Now, there may be things that can be done that the court has in terms of the GPS, in terms of how payments can be made, because courts can do things in terms of how payments are made, even on an interlock. Okay? So, but my point is, what's alleged here in this PC affidavit is troubling to the court.
Right. I
Okay?
understand that.
And so I'm more concerned about safety of the victim. That's one of the when you have rules for setting bonds and conditions of bond, that's one of the things that that the court has to take into consideration. Yes.
I just want to say,
Well, talk to your lawyer first and see before you say
I just
anything.
want to let them know that people make mistakes. People say things
Well-
they don't mean. So, I mean, I understand what you're saying. So
Okay.
that's something that I did and I have to man up to it.
Oh.
But I'm not, that was never gonna happen.
Okay. Well. Okay. So at this time, that's the ruling of the court. The case is going to be, how much time do you need, Mr. Burbank?
Oh, I'm ready now, if you want to pick a jury for the terroristic threat.
Which
We can get 6 people right now outside, because, I mean, I'm just trying to get this solved and not jam up the district attorney so we can come to an amicable agreement.
Yeah, but
And for the record, yeah, I could try it right now.
yeah, but it wasn't set on the trial docket, it was set on the announcement docket.
We prefer the
MTRP.
revocation hearing first, Your Honor.
So, we need I think at one time you sent a 30-day reset.
Yeah, sure.
Okay, give him a 30-day reset.
August 13th.
Okay, it's reset to August 13th. And Mr. Martin, make sure you adhere to those bond conditions. Okay, because your failure to adhere to them could result in you being arrested and placed in the county jail. Okay, August 16th, 13th.
Let me be excused.
Yeah,
for
get
that
your,
date,
yeah,
Chairman.
yeah, get your reset. You'll be free to go and you have a blessed day. Well, hold on.
You got so many
Okay, well, Mr. Well, let's do this here. Let's get Mr. Freeman. Do you have another one, Mr. Freeman?
No, sir. I just, he's on the phone.
Oh, okay. Okay, we can go ahead on and get your case. Yes, Mr. Is that Zaccharies? Mr. Zaccharies?
Yes, that's Zachary Johnson.
How do you pronounce your first name?
Zachary?
Zaccharies. Okay. Okay, this is cause number 326166, State of Texas versus Zaccharies Johnson. We have Mr. Johnson appearing via Zoom. Mr. Johnson, thank you for being patient with us. And we have Mr. Johnson's attorney, Mr. Antoine Freeman, who is present in court. Mr. Freeman, how are you doing?
I'm good, Your Honor.
Okay, Mr. Johnson, how are you doing?
I'm all right. I'm blessed.
That's good. Now, Mr. Freeman, do you have an announcement you'd like to make in Mr. Johnson's case?
Your Honor, our announcement would be to ask for a reset to make another announcement on them.
Okay, do you have your discovery and offer from the state?
I do have discovery.
Okay,
But we have some confusion about how much time Mr. Johnson has spent in jail.
oh, okay,
So we're looking at a jail offer as well as a probation offer.
okay.
And I've talked to the DA's office.
So you just
And we
need
wanna
you
look-
just need more time to negotiate?
Yes, sir. We want to look to see if he does have any credit in jail or is it a computer glitch?
Okay, okay, so we'll reset it. How much time you need?
30 days would probably be
Okay,
fine.
give us a date.
August 27th.
Okay, it's reset to August 27th. You can get your reset. Mr. Freeman, once you get your reset, you'll be free to go and you have a blessed day. And Mr. Johnson, stay in contact with your attorney. Your attorney will be given a reset date. You stay in contact with your bondsman as well. This will conclude your case. Again, thanks for being patient and you have a blessed day. You're excused.
Okay, thank you, sir.
Okay, you're welcome. Oh, that's right. You, We're back on the record in the court's motion to revoke probation docket and the court's announcement docket. We have just finished with the cases called in the docket, and so we'll go back to cases for people who failed to appear or who have left the court and did not reappear. First case is cause number 316666. The case is styled the State of Texas versus Robert Jason Vincent. Miss Redmond, did Mr. Vincent, do we have anything to see if he got notice? I see he is out of town. Oh, it was? Okay.
I know it's fine.
Mr. Robert Vincent was scheduled to be in court this morning for the court's motion to revoke probation docket, which started at 9 a.m. on today's date of September 6th, of July 16th of 2021. His name was called at about 9 a.m. by the court's bailiff. He did not answer, and he has not appeared in court while the court has been in session. The time now is 12:12 PM on today's date. Mr. Bailey, would you please call the name of Robert Vincent? Robert Vincent. Robert Vincent's name was just called by the court's bailiff. He did not answer. A reasonable time has passed to give Mr. Vincent an opportunity to appear in court. He did not appear. State, do you have a motion?
Yes, Your Honor, the state would move for KP's and bond forfeiture.
Okay. That will be granted. A warrant will be issued for the arrest of Mr. Vincent, and warrant and his bond shall be forfeited. And cause number 316666. We are on the record in cause number 320588 and state the case is styled State of Texas versus Kelly and McGee. Kelly and McGee was scheduled to be in court this morning for the court's motion to revoke docket at 9 a.m. Her name was called at or about 9 a.m. by the court's bailiff at the courthouse door. She did not answer. She has not appeared in court since the court has been in session. The time now is 12:13 p.m. on today's date. Mr. Bailiff, would you please call the name of Kelly McGee? Kelly McGee name was just called again by the court's bailiff at the courthouse door. She did not answer. A reasonable time has passed to give Ms. McGee an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
Yes, Your Honor, and the state would move for bond forfeiture at this time.
That will be granted. In cause number 320588, Ms. Kelly McGee's bond will be forfeited and warrant shall be issued for arrest. We're on the record in cause number 320809. The case is styled the State of Texas versus Brandon Forward. It's Brandon Rochard Forward. Mr. Brandon Rochard Forward was scheduled to be in court this morning at 9 a.m. for the court's motion to revoke probation docket. His name was called at about 9 a.m. by the court's bailiff at the courthouse door. He did not answer. He has not appeared in court while the court has been in session. The time now is 12:15 p.m. on today's date. Mr. Bailiff, would you please call the name of Brandon Forward? Brandon Forward's name was just called again by the court's bailiff. He did not answer. Therefore, well, State, do you have a motion?
Yes, Your Honor, the state would move for bond forfeiture.
That motion will be granted. Brandon Forward's bond will be forfeited and a warrant will be issued for his arrest in cause number 320809. We're on the record in cause number 320716. The case is styled the State of Texas versus Darrell C. Woodside. Mr. Darrell C. Woodside was scheduled to be in court at 9 a.m. on today's date. Mr. Woodside did appear in court with his attorney, Mr. Jack Lawrence, and Mr. Woodside left out of the courtroom stating that he was going to talk to his brother, and he has not reappeared, and that has been at least, I guess, over an hour. I don't know the exact time that he walked out, but he walked out sometime. That was over an hour, and Mr. Woodside has not reappeared. Mr. Bailiff, would you please call the name of Darrell Woodside?
Darrell Woodside. No response, Your Honor.
State, you have a motion?
Yes, Your Honor, the state would request a bond forfeiture.
That motion will be granted. Warrant will be issued for the arrest of Darrell Woodside, and his bond will be forfeited in cause number 320716.
Your Honor, if there's some way to note it, he has very serious medical problems. Both sugar diabetes as well as very high blood pressure. And he's down to about 120 pounds. He doesn't weigh too much of it. So if it becomes necessary for them to take him to jail, he needs to be looked at pretty quick in the medical.
Okay, that information need to be provided to the jail.
Yes.
Okay,
Thank you, Jim.
okay, you're welcome. You're excused. You have a blessed day. We're on the record in cause number 326140. The case is styled the state of Texas versus Robert James Williams. Robert James Williams was, he's in jail. Okay, we'll skip that case. He's currently in jail. And that will conclude the calling of the court's announcement docket and the court's motion to revoke probation docket. Okay. That will conclude both dockets in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. And everyone have a blessed day.